The highest court in Maryland recently declared unconstitutional a Maryland law that allows DNA to be collected from people charged but not yet convicted of violent crimes. We talked with Attorney General Doug Gansler earlier this week. He told us that he thinks that it's a crucial tool for law enforcement and that he's hoping the U.S. Supreme Court will look into the matter. It is my understanding you feel the same way. Why?
Absolutely. We do feel that it really is a crucial tool for us. I give you an example. We had a conviction 2 weeks ago in the case of Billy Joe Simon. This was a cold case, a homicide that occurred about 10 years ago, and we were able to solve the case and then to later earn a conviction in a cold murder case using DNA evidence. We find, especially in homicides and in rape cases, this evidence becomes a critical tool for us, and we agree with the Attorney General that we hope that the Supreme Court will take a look at it and reconsider.
Well, let me cut to the chase. The hub of the argument here is that I guess you make the argument that there is really no difference between fingerprints and DNA. And we're talking here about people who are arrested and charged for a crime but not necessarily convicted. Other people say the crucial difference is that fingerprints only tell you about the individual. DNA can also tell you about the relatives of the individual, and that A, what happens to that DNA if the person is not convicted of a crime, and B, when that DNA is sent to the federal level, there is no Maryland jurisdiction over how it will be used, so it can be used to tell whether my cousin committed a crime someplace. What do you say in response to that?
What I can say to that is this. If you are exonerated of a crime that includes DNA evidence that's been collected to you from you as an arrestee, you have the right to have your attorney file to have that evidence destroyed.
Otherwise, you're not going to destroy it, huh?
Otherwise, it remains in that database.
Just DNA or all kinds of evidence?
No, if you have your DNA sample collected as an arrestee and you are later exonerated, found not guilty of that crime, your attorney can then file a request using the certified copy of that not guilty and have that evidence destroyed. And so it is not the case that if you are exonerated, the DNA remains in that database in perpetuity, or it does not have to.
If you do, it doesn't have to remain in perpetuity. If you do nothing, it can. You have no control over what happens when it's sent to the federal government, however.
No, we do not have any control over what happens if or when it's been sent to the federal government.
And what happens if the law changes in Maryland at a later date that allows you to hold on to that DNA, even if my attorney tries to get it removed after I'm exonerated?
Then we're able to use it as a tool if your DNA matches a later sample. And so generally what happens, even in the case that I mentioned, is if you are later arrested and your DNA is collected, and a match occurs, then it gives us a way of solving some of the other cases, a rape case, homicide cases, and we are able to use that evidence.